record reflect we are back in session. Parties and counsel are present. All members of our jury or alternates are present. Our witness is back on the witness stand. And Mr. in the lead, you may resume your examination.
Can we approach briefly before we begin?
I'm sorry?
Can we approach briefly before we begin?
You couldn't have done that before we started.
I just came up.
All right. Was the recorder?
Yeah.
Oh, yeah.
Thank you.
Good morning.
We left off yesterday. You were about to answer a question on your interview with Mr. Merritt. He was the security guard at the San Ysidro Strip Center. Is that correct?
Yes.
And he had indicated to you that he saw the Isuzu trooper, and he told you the approximate time that it got there. Is that correct, or that he saw it?
Objection misstates the testimony of prosecutors.
You did interview Mr. Murray, correct?
Yes.
And based on what Mr. Murray told you, you went and pulled some surveillance tape, and you limited your surveillance tape to certain hours, correct?
That's correct.
And the hours that you chose were based on what Mr. Murray told you?
That's correct.
And what did Mr. Murray tell you?
Objection here, sir.
Overruled, offered to explain his conduct in selecting the time frame.
From memory, he believed that the first time he saw was around 5 p.m., I think he said.
Can we ask for an instruction as to that? Yeah. That is not offered for the truth.
Sure. So when someone like the detective is relating something that someone told him, it's not being offered to prove that that is true. It's only being offered to prove that's what he was informed of, and he used that information to make subsequent decisions. Whether or not the underlying information is true or not would depend on other evidence. And there may not be other evidence. So the only thing that's relevant here is what he was told to explain what he did or didn't do. Okay?
Isn't it true that what he actually told you was Mr. Murray estimated 1,900 hours?
I'm sorry?
Objection, it's hearsay and lacks foundation.
Overall, it's still admitted for the limited purpose.
Isn't it true that what he actually told you was that he had estimated it was probably around 1,900 hours, and that he did not believe the car was parked there prior to 5 o'clock?
I don't remember that specific.
Do you have your report, though?
Yeah, I do.
And you have page 3?
Yes, I do.
Third paragraph? Last two sentences?
What's the dates?
6101.
To be specific, what he told me is that he thought it was around 7 p.m., but he didn't believe it was parked there prior to 5 p.m., but he wasn't confident on that. He's just giving me information.
Okay. All except the part where you just added that he wasn't confident about it
Objection.
was in your report, correct?
Hearsay.
The objection sustained is argumentative.
So, based on what he tells you, so he's telling you that he didn't believe it was there before 5 o'clock, but probably around 7 o'clock.
Same objection, Your Honor.
And
The objection sustained is cumulative.
And you went to and you requested what time for the surveillance videos?
I don't specifically remember what time I requested. If you have it in the...
Would it refresh your recollection?
Yes.
Okay.
On which page?
Well, you can start with the same page, look at the paragraph above, and you can join with page 4 of your report. Be page 6102.
looks like what I requested was what the security guard was relaying from 5 p.m. and then I made an end time of just prior to midnight, 23:55 hours.
And do you remember watching that surveillance video?
Not in its entirety, but at each business, if it was available, I sat and watched just some clips to see if they had view of the exits and entrances and also the location where the car was parked. Then I requested that they would copy that surveillance video so I could later take it to my work and myself and other detectives could view it.
Okay. Since you said that he wasn't that confident, why didn't you ask for the whole day?
In hindsight, that would have been wonderful, but when you're doing a missing persons investigation and somebody tells you, I don't think it was before 7, it was maybe after 5, I just go on that word and say, okay, let's go from 5 p.m.
This interview happened the very next day after you were on the case, correct? This was the 16th of February?
That's correct.
You were on the case for over 2 years, correct?
I've been on the case for 9 years, but this was the next day after it was reported the family was missing.
Right. So, but when you were an active, I would say actively involved.
Oh, you're asking my experience as a homicide detective?
No. I'm asking, you were on the case actively on a day-to-day basis until a certain date, correct? When you
Yes.
turned it over to the FBI?
That's true.
Okay. So that was more than 2 years from this date, correct?
It was more than 2 years.
Okay. Did you ever go back to the shopping mall or the shopping center and ask for more videotape?
No.
Why?
In my experience, nobody saves videotape realistically past a week, past a month I've never heard of that. So by the time we got beyond that time frame, it would be ridiculous to even attempt, but
Well, we saw Ms. Mitchley's video that I believe she indicated that she had some limited time frame, either it was a week or a month or whatever her time. She had a small home system, correct?
that's correct.
These systems that the businesses have, especially the ones across the street, the big shopping center that you indicated that had, I guess, a control room, right?
That's correct.
Those are a little more sophisticated surveillance systems. Would you agree?
Objection lacks foundation.
Sustained.
Speculation.
Sometimes more elaborate security systems will have longer duration. Would you agree?
Objection vague, lacks foundation.
Sustained. Also, relevant surveillance.
Bottom line is you never went back to even request it, correct?
Correct.
On the 17th of February, the next day, you indicated that you did some follow-up investigative work. One of those things was that you interviewed Mr. Merritt, is that correct?
That's correct.
And that was with Detective Fisk,
Yes.
with an E,
Yes.
at Mr. Merritt's, I guess his apartment, where he lived.
The apartment complex community center.
And you also followed up with Detective Layback regarding the Mitchley video, correct?
Yes, his name's pronounced Leibach.
Leibach, sorry about that.
That's okay. I did, on more than one occasion, follow up and actually directed him to go back and request or talk to her about trying to obtain the entire unit for imaging.
And is that the day that you had contacted her? Because you had got information that she was being a little bit uncooperative, correct?
That's correct.
And did you contact her personally after that, or was that something that Leibach did?
He contacted her. He relayed to me that she was uncooperative. I decided to contact her on the telephone and tell her how important it was that we obtain her surveillance video so I could image it. I had a conversation with her on the phone. She once again refused to give us what we requested.
She refused to give you the system, correct? The actual
That's correct.
system.
That's correct.
Okay. But she had no objection to you plugging in a thumb drive and recording everything that they had on the system, on her system, correct?
That's incorrect.
That's incorrect.
That's incorrect.
So if she testified here that she didn't mind any officer coming over and pulling anything off the system or recording anything off the system, that would be inaccurate.
Objection calls for speculation and mistakes the evidence.
Overruled.
I didn't hear her testimony, but if that was her testimony, it's far from reality.
Now, you had mentioned some voicemails yesterday. Do you recall the testimony about voicemails?
I do.
These are voicemails that were left on Summer's cell phone and Joseph's cell phone.
That's correct.
Okay. And counsel here was asking you questions about, first on Joseph's cell phone.
Yes.
Okay. And you actually were able to listen to those as well, correct?
I was.
And I think you indicated on Joseph's there was 25 voicemail messages, correct?
I don't think I gave a number, but I believe that's accurate.
Do you have your report
I do.
to refresh your recollection to look?
I don't have the report of the cell phone. Thank you.
It's in bold print in the middle.
25 voicemail box messages.
And at the time that you looked at it, or at the time that you heard the voicemails, the mailbox was full, correct?
That's correct.
Okay. So, and counsel had a series of questions about Mr. Merritt not calling. You didn't hear Mr. Merritt's voicemail on Joseph's voicemail, correct?
Correct.
Okay. But you also didn't hear Joseph's mother's voicemail on Joseph's cell phone, correct?
I addressed that in my initial statement. That's correct, though.
Okay. And you didn't hear Michael, his brother's voicemail on his phone, did you?
No, I would have expected it.
Okay. And you would have expected him not to leave a message, or you would have expected him to?
No, all those persons, I would have expected voicemails would have been on Joseph's because those persons were, not every one of those persons, but they were on Summers, which was more ordinary to human behavior.
Okay. So, but there's a good reason why none of the close family members or Mr. Merritt were on Joseph's emails, right? There was a good reason for that?
Objection. We didn't talk anything about Joseph's emails.
I'm sorry, Joseph's voicemails.
What's your question again? I locked on the...
There's a good reason why none of those close family members or Mr. Merritt's voicemail was not present on Joseph's phone,
Objection
correct?
calls for speculation.
Sustained.
Counsel asked you about the timing of those voicemails, and you indicated that people were calling concerned about Joseph, right?
About Joseph missing.
Correct. And
Because
they
I
had,
saw it on the news.
in fact, the second call in was a friend indicating that he had read in the newspaper about the missing family, correct?
That's exactly right.
Okay. And by the time you got involved on the 15th, was your first involvement, September 15th,
Yes.
and by the time the press got a hold of it and started printing stories, do you recall when that was?
No,
But it was certainly after the 15th of September, correct?
absolutely.
Probably closer to the 19th, when you actually did the search warrant, correct?
I don't know. I don't know when the news started broadcasting. I was busy doing an investigation,
Well,
but...
you saw the television camera at the search warrant, correct?
Oh, there was. Yes, you're correct.
Okay, so around that time is when the press got involved. Would you
Well, I
agree?
would say that confirms that on the 19th, the press was involved. I don't know if they were involved before that.
Okay, so these messages on Joseph's machine, since the second message out of 25 was regarding the media, the newspapers, correct?
Correct.
Means these messages started around that time. Would you agree?
Objection calls for speculation.
Sustained.
Were there any messages on Joseph's machine from February 4th to February 19th that you're aware of?
Objection. lacks foundation. He's already testified regarding.
Overruled can answer if he knows.
To the best of my knowledge, there's no way it could have been prior to the 15th because that's when I got involved. That's when there's a potential for my command to release a press release to the media. I don't know when that was done. That's not my job. And I wasn't watching the news, I was working.
Okay. But you knew, based on your investigation, subsequently that Joseph's mother had called Joseph between the 4th and the 15th, correct?
Objection.
That's what she
Misstates
told you?
Testimony.
I'm
And
sorry,
hearsay.
what's the objection?
Misstates the evidence and hearsay.
Overruled can answer.
Joseph's mother told you, or Detective Liebeck, that she had called her son,
Objection
correct?
lacks,
After the,
lacks foundation if it was told to someone else.
Sustained.
did you subsequently learn that family members, Michael, his mother, had called Joseph's phone between the 4th and the 15th?
Objection lacks foundation.
Overruled can answer yes or no.
Yes, but I don't know exactly when they did it. It was in that time frame.
Okay, so if these messages started on the 19th or shortly before the 19th when the press got involved, their messages wouldn't be on here, correct?
Objection misstates the evidence as to when the press got involved.
Sustained is cause for speculation and conclusion.
So there's a big chunk missing of voicemails. Would you agree there's a big chunk of time missing from Joseph's emails, starting with the first one? Would you agree?
Vague. We're not talking about emails. We're talking about voicemails.
Oh, sorry, voicemails.
And it calls for speculation is due a big chunk.
Sustained is phrase.
Would you agree that from the February 4th to around February 19th or 18th, those voicemails are missing?
Based on my experience dealing with voicemail messages, comparing it to Summers' voicemail messages, I believe there was a block of messages deleted that should have been there from the dates you're talking about, February 4th to February 15th.
Thank you. So, and you factor that into your investigation as well, that you believe these voicemails had been deleted, correct?
I consider it. I don't know how much I factor it in, but I consider it.
Now, you're also aware that Daniel Cavanaugh had indicated to your homicide team, I don't know if it was you in particular, that he could get both Summers and Joseph's password to the voicemails, correct?
Objection. Hearsay lacks foundation.
Sustained.
It shows subsequent action, Your Honor.
Still
Not
lacks
offered for the
foundation.
truth.
Still lacks
The objection sustained.
Did you get information regarding the password to Joseph's voicemail?
Objection. Assumes facts not in evidence.
Overruled can answer yes or no.
I don't specifically remember how I got that or if I got that. The Kavanaugh thing, I don't remember it being in
Objection.
cell phones.
Move to strike. That we don't question any regarding that.
Sustained. The last portion of the answer is stricken. Jury is instructed to disregard the last portion of the answer.
But you had the password.
Well, I listened.
Objection.
You,
Assumes
hold on.
facts not in evidence if there was a
I just
password.
finished the question.
Yeah.
You had the password.
Just a minute. You can ask him if he obtained the password for Joseph's phone.
Did you obtain the password for Joseph's cell phone, the voicemail?
I have no memory of that. I remember the phone company giving me the voice messages, so I would believe I would have direct access to the voice messages. But if it's in my report, please direct me and I'll refresh my memory.
Well, you can look at your report. Do you have your report with you?
Yeah.
You don't have that one. It might be in the first paragraph. Does that refresh your memory?
Yes.
Okay. So T-Mobile gave you an access code, correct?
That's right. I received the information from T-Mobile.
But T-Mobile didn't give you a password, correct?
Objection, vague, argumentative?
Overall,
Well, my understanding of an access code would probably be comparative to a password. So that was in 2010. That's how I accessed their voice messages.
Did you ever find out who deleted those voicemails?
No,
Did you ask anyone, let's say, Mr. Merritt if he deleted those?
no, I would have at that point had to believe Mr. Merritt was in possession of Joseph's phone.
Did you ask Daniel Cavanaugh if he deleted those?
No,
Did you ask anyone if they deleted it?
no,
Did you ask T-Mobile, since they gave you the access code, when and if those voicemails were deleted?
no.
Why?
I don't know.
Now, Summer's voicemail messages. She had 31.
That's correct.
Okay. First, would you agree that her time frame on her voicemails are a little different than Joseph's?
First, are consistent with my experience reviewing voicemail messages, time frames, what's happening during that time frame.
Okay. And Daniel Cavanaugh called and left at least 2 voicemail messages on Summer's phone. Is that correct?
I remember that.
Okay. And the first voicemail he left was that he had been trying to get in touch with Joseph for the past 5 days.
Objection, hearsay. Lock stumbles.
Well,
sustained.
was there anything in the voicemails that would, or the voicemails from Mr. Cavanaugh that would give you an approximate time as to when he left the voicemail?
Approximate.
Okay. And what would you say that would be for Mr. Cavanaugh? Let's start with Mr. Cavanaugh. When was his first voicemail left?
I would have to see the report.
Okay. Let's see if I can do this without having to walk up there again, okay?
Okay.
If Mr. Cavanaugh said in his first voicemail that he's been trying to reach Joseph for the past 5 days, would that have helped you date as to when he approximately left that voicemail?
Not specifically, because I would have had to have the knowledge of the last time he contacted Joseph McStay, which could have been even before February 4th. But it was consistent, again, with somebody's looking for them.
All right, I'll walk up. And then you can look at the next one, number 5, too, to see if that will help you date it. So Dan Cavanaugh's will be number 4, and then you can look at the next one, number 5.
Okay, I hope I can remember all those different contacts. But
Does that refresh your memory?
yes, but my answer's not going to change. Number 4 does not give me any more help on what that previous 5 days was. It just kind of indicates that Dan Cavanaugh is aware that they're missing. Maybe he was aware they were missing prior to February 4th. I don't know. Or maybe he believed that. In number 5, Patrick McStay was contacted by Dan Cavanaugh, and essentially the telephone chain of family and coworkers are flying on where is everybody. And that was on February 10th, when they absolutely were believed to be missing by, well, thought to be missing by the defendant and Michael McStay, I guess.
Well, you write in your report that Patrick McStay called on Wednesday, February 10th. So number 5 is a message from Patrick McStay on February 10th.
Objection, it's hearsay.
Is that correct?
It's being offered for hearsay
Objection
purposes.
sustained as hearsay.
Did that statement refresh your recollection as to when Patrick called?
Objection, same objection.
Sustained.
So, would you agree that Dan Cavanaugh's voicemail would have been either on the 10th or the 9th?
Objection lacks foundation, calls for speculation.
Sustained.
Did you check, for example, were you able to check Mr. Cavanaugh's phone records to
No.
see when he called?
No.
Did you request his phone records?
I would like to have done that.
I'm asking you, did you request them from the phone company?
No.
Why?
Phone companies require a search warrant, and I'd explained exactly how the judge had directed me. I needed a link to persons to obtain search warrants for other people.
I understand, but you also said that you call sometimes, and some companies comply without a warrant,
He
correct?
states the testimony, that's with regard to financial records.
Did you also call regarding phone records?
I have never received phone records based on a request other than a search warrant in my career.
Let's talk about financial records. Did you request any of Dan Cavanaugh's financial records?
No.
And was that because you needed to have a warrant?
No. I never requested, so I don't know what they would have offered.
Okay. Now, talking about Patrick McStay, at some point you were in contact with Patrick McStay, correct?
Yes.
And soon into your investigation, Patrick McStay would also give you information, correct? To try to help.
He would give me his beliefs.
He would give you whatever information he gave. Whether you use it or not is your decision, correct?
Oh, I used it.
Okay.
I would follow up on it, and in every instance, it was disproved.
Okay. So he contacted you. I'm going to fast forward a little bit, so I apologize. Mr. Patrick McStay, and who is that, just for reference?
The adopted father of Joseph McStay.
But raised Joseph, obviously treated him as a son, thought of him as a son, and so
I
forth.
have no idea how he
Objection,
treated him.
relevance, calls for speculation.
Sustained.
Move to strike.
If there was an answer instructing the jury's instructed to disregard it.
He provided you information in July of 2011 that Dan Cavanaugh had been.
Objection, calls for hearsay.
Sustained.
Did Mr. Cavanaugh give you information about the sale of EIP and asked you to look at it?
Objection, lacks foundation. Here's
Overruled against yesterday.
You're asking me if Dan Cavanaugh gave me information about selling?
No,
EIP?
Patrick McStay gave you information.
objection, relevance.
Overruled. The objection sustained. Mr. McStay wouldn't have had personal knowledge.
Well, my question is, did Patrick McStay give you information regarding the sale of EIP in July of 2011?
Same objection.
Objection sustained on relevance to grounds in the law foundation.
We'll get to that. We'll come back to that. But Your Honor, I don't want to address the 1101B of the third party stuff in front of the jury. I'll wait to the break, otherwise, unless you want me to be heard on that matter regarding.
You've already been heard on it, the court's already ruled on it.
I understand. I agree. The court's ruled on it, and that's what we want to talk about. So,
Or there's no reason to talk about it again.
well, okay. You mentioned the border video. That was a video that you got from the San Ysidro border, is that correct?
Correct.
And do you know when you got that video and began viewing it?
I obtained it. It was probably a week or so after the missing persons case began. Once I obtained it and began to look at it, I realized it was overwhelming and that I would need assistance. So it took a little bit longer, and I'm talking days, maybe even weeks, before I actually got NECMEC on board and persons supporting NECMEC to assist me with viewing that video.
Approximately, what would you say it was after February 15th? How long after that?
Before I had put it in front of the family to say this is what we believe,
Correct.
or this is what we see, not what we believe.
Correct.
Couple months.
Okay. And in regards to what you believe, you had actually told several of the family members that you personally believed that it was Joseph, Summer, and the kids. Correct?
No.
You never said that?
No.
Okay. But they would come in and give you their opinion. You had them watch it, correct?
That's correct.
And several family members came in and watched that video.
I specifically remember Michael, Tracy, MacGyver, Susan, and Blanche, I believe. Also saw it.
Mr. Merritt did as well?
I don't remember him viewing it.
What about Dan Cavanaugh?
No.
And did you testify earlier on direct that it was universal regarding the family that they thought it was? The family?
Objection misstates the testimony.
Overruled, changed.
Yeah, you're lumping them, and maybe if it came across to you that way. Each person had a different opinion. Not one person said, no, that's not them. But logic prevailed, and each person said, how, you know.
None objects, that's hearsay on the strike.
Overruled.
Essentially on the negative side, if it was not them, they're saying, how can you tell? And I said, I can't tell. I'm asking you. That's your family. I don't know. I never met them. On the strong side, the mothers were much more affirmative, saying they believe that certain parties in the video were their family members.
Okay.
Objection hearsay again with the strike.
Overruled, yes, sir.
And so the fact that the family crossed, the family that you viewed on the video crossed on February 8th, combined with the fact that the car was found near that border crossing on the 8th, those factors led you to believe that, and you wrote in your report, that those factors led you to believe that that was the family. Would you agree?
Not as definitive as you put it. In law, we deal with probable cause. I believed it was probable that it was them based on the family's assessment, but it was almost equally probable that it was not them because we had no facial features and it was a grainy video from behind them, dim lit area. It did fit for a time frame, that's it.
Okay. But you did mention in some of your interviews with family members that that's a pretty big coincidence that the car is located there and then the family resembling the McStays cross on that day. You did mention that to them, correct?
Objection misstates the testimonies to
Objection
objection.
sustained, cumulative.
And would you say that after you viewed the videotape, I'm talking about you, because you're still the lead detective, correct?
Yes.
That you treated this on a going forward basis strictly as a missing persons case, as opposed to something else.
No.
Did you execute any search warrants after the border crossing video?
No, I've already explained I didn't have enough probable cause to bring before a judge to give me a search warrant.
So the answer would be no, correct?
No.
Okay. And let me ask you this. Okay, going back to the time of February 4th and the subsequent 2 weeks after that, you mentioned PayPal records on direct examination. Mr. Doherty asked you if you had requested PayPal records. Do you recall that?
I did, and I did. I do remember, and I did request records.
And they gave you, I think you indicated PayPal gave you records, correct?
Yes, my memory serves me, yes.
And they without a search warrant.
That's correct.
And see if these are the records that you got. Start with that. Does that look familiar?
No. It is probably an accurate reflection, but when I received it, because I'm not a financial crimes expert, I took all the financial documents I received and gave them to the financial crimes sergeant, who then gave them to the financial crimes detective, who I sat with and gave a briefing about this case, and he reviewed all of it, so.
And he gave you information off of the records? Is that the way it worked?
And he was assessing them to see if there was something we could pull that would link us to give probable cause to look at other persons in this case.
Okay. So, when you reviewed those records, you learned that there was at least 5 transfers.
Objection, hearsay, last foundation.
Sustained.
When you reviewed those records, did anything, did you see any suspicious activity on Joseph's PayPal account?
Objection, call for speculation, vague, misstates the evidence. And last foundation.
Overall, we can answer for the basis for further investigation.
I did not personally review those records. I directed the sergeant to have a detective assist me with reviewing those records.
Did that sergeant brief you on some suspicious activity that required you to then interview Dan Cavanaugh, or ask Dan Cavanaugh
Objection,
questions?
hearsay, last foundation.
Sustained.
Did you get information from that sergeant about the PayPal records that caused you to do something further?
Same objection.
Overall, yes, yes, or no.
I don't remember if the information came from the sergeant or from the detective or from April Coronado.
From someone. Let's change my question too. Did you get information from someone regarding the PayPal records that caused you to do something further?
Well, sure, I was investigating. Yes.
So that's a yes?
Yes.
Okay. And what did you do regarding that information? What was the investigative step that you took?
Regarding, I need more specific.
You got information, correct?
Regarding the PayPal accounts?
Yes.
I interviewed persons that were involved. They were business partners.
Who did you interview regarding the PayPal?
I know I talked to the defendant about it. I know I talked to Dan Cavanaugh about it.
And you talked to Dan Cavanaugh and you asked him some questions, correct?
Many.
Okay. And did you ask him questions about some transfers that were made starting on February 6th?
I'm sure I did.
Okay. So you learned that Mr. Cavanaugh had made transfers.
Objection, hearsay, last foundation.
Sustained.
What was suspicious and why did you question Mr. Cavanaugh?
Objection, hearsay.
Sustained.
What did you ask Mr. Cavanaugh when you talked to him?
If he had a legal right to be in the business finances,
Okay. Because he got into the PayPal account.
Objection, hearsay, last foundation.
Sustained.
And what did Dan Cavanaugh tell you?
Objection, hearsay.
Overall,
yes, he had access.
So Dan Cavanaugh told you that he could go into Joseph's PayPal account and transfer money.
I don't think he told me those exact words, but he said he had access to the business financial records.
Would you agree that there's a difference between access and being able to take?
Objection, vague.
sustained is vague and ambiguous, also calls for speculation and conclusion.
You asked Mr. Cavanaugh if he had access, correct?
Yes,
And Mr. Cavanaugh told you that he had access, correct?
yes,
Did you ask Mr. Cavanaugh if he was authorized to remove funds from Joseph's account?
Objection, hearsay, last foundation.
Sustained, seriously.
What other questions did you ask Mr. Cavanaugh in that regard?
Objection, vague. Last
Sustained
foundation.
on, at this point, sustained on relevancy grounds and hearsay.
You asked Mr. Cavanaugh questions, and then did you take any subsequent action after asking Mr. Cavanaugh questions?
Objection vague.
This investigation was ongoing. I talked to Mr. Cavanaugh and the defendant several times about financial records, about the business, who did what, how the money flowed. I got answers from both of them that were consistent, that they had access.
Money flowing out of DIP and Joseph's accounts was an important issue for you, correct?
Oh, absolutely.
Okay. And you would want to know whether persons were taking money out of the account, because that would be important to your investigation, correct?
Absolutely.
Okay. And did you learn through your investigation that Mr. Cavanaugh was taking money out of the
Hearsay,
account?
Lux Foundation.
Sustained.
Did you get an email from Mr. Cavanaugh, did you get an email from Mr. Cavanaugh on March 11, 2010?
I hope you're going to show me. I got emails from
Sure.
Mr. Cavanaugh.
See if this refreshes your memory.
Yeah, yes.
And Mr. Cavanaugh sent you an email. Oh, you may want to look at the attachment. There's an attachment to that email, correct?
There is.
Okay.
Yes.
And would you agree that the email suggests that you had requested some information from him and he's sending it to you?
That's correct.
Okay. And what in the email, what did Mr. Cavanaugh send you?
He says that he had access.
Objection, hearsay, Lux Foundation. As to who sent the
You're
email.
asking for the substance of what was sent?
Just what he sent him.
That also lacks another foundation.
You're asking for the substance of what was sent. The objection sustained is hearsay.
I'm just asking what, he asked him a question to get information and it was sent to you, correct?
Yes.
Okay. So my question is, what did he send you?
And my objection is it lacks foundation and it's hearsay.
Well, I mean, I'd have to see it. I don't know.
You can show the court.
For the record.
Sure. You can inquire pursuant to the court's ruling.
Thank you, Your Honor. Did Mr. Cavanaugh send you, in response to your questions, information representing transactions regarding the EIP PayPal account from February 10th to February 12th?
Yes.
And he sent you information representing transfers.
Objection.
Sustained.
Do you know what do you know what those? Do you know what the representation in those in the attachment that he sent you? Do you know what he was representing?
Objection. Calls for speculation.
Sustained.
Do you know what you asked for?
Assistance, for the financial assistance from the business.
Well, his email to you is rather specific, correct? Regarding the attachment that I just asked you about from February 10th to February 12th?
He asked for data for the transfers on PayPal that I requested,
Okay, so you request, your request was actually specific, correct?
according to this. I don't remember that statement,
But that refreshes your memory, right?
but it does.
Okay, so you asked for specific information and he gave you specific information, correct?
He gave me a list of 4 transfers.
Objection. Marks Foundation.
Sustained. Calls for speculation.
Move to strike the answer.
He gave you a list of what he was purporting to be transfers, correct?
Those are better words.
Those weren't the actual financial documents.
That's correct.
Thank you, Your Honor. That was a good question. Did you then go and
That's what
compare?
I told you you could have.
Thank you. Did you then take what Mr. Cavanaugh sent you and compare it to the actual PayPal records?
No,
Why?
because at this point, I had family members that were drawing up DBAs, doing business as documents. I had 2 business partners who were telling me that they had access and they were continuing to run the business. There was people calling me saying I'm not getting my fountain. So to manage that was impossible. Without Joseph's words, it was what it was on face value.
Detective DuGal, you yourself testified you needed probable cause to go back to that judge.
Absolutely, and I look for it, and you can't bring it to a judge when the family's running a business and the 2 business partners claim both that they had access to these documents prior to Joseph being missing.
Stealing money from Joseph would be probable cause, wouldn't it?
I would have loved to prove that. I still can't prove that.
Have you ever reviewed the PayPal records of Dan Cavanaugh? Ever?
No,
Never.
no.
Have you ever reviewed the PayPal records of Joseph McStay?
I don't even know that Dan Cavanaugh has a PayPal.
Objection, non-responsive. Move to strike.
Overrule the answer.
Are you sitting here telling the jury today, after being on the case for, as you say, 9 years, that Dan Cavanaugh, you don't know if Dan Cavanaugh had a PayPal account?
Objection, argument.
Sustained.
Do you know where all these PayPal transfers were going?
Objection, vague.
Sustained and argumentative.
For Dan Cavanaugh, you could have just written a letter to PayPal and they would have given you those records, correct?
Objection.
Sustained. Seems that's not the evidence. Calls for speculation and conclusion.
You did testify that PayPal, you wrote a letter to get Joseph McStay's records, correct?
I
You just
believe
requested it,
a letterhead, yes. A letterhead meaning my business.
and they gave it to you, correct?
Yes.
Okay. Why didn't you request the same for Dan Cavanaugh?
Because he was working out of the business PayPal. I
Okay.
didn't know that Dan Cavanaugh would have another PayPal account related to him or any other business.
Right, but that's what you do, right? You investigate, you check,
Objection, argument.
correct?
Objection sustained is argumentative.
I don't know if I got an answer to this question.
You didn't because the objection was sustained.
I didn't ask it yet, Your Honor. It's a preface to my next question. Did you ever check, did you ever yourself view Joseph McStay's PayPal records?
Not in an investigative format.
So when you got this list from Dan Cavanaugh, what did you do, if anything, to determine whether what he was sending you was accurate?
Question the business partners.
Okay, so well, that's Dan Cavanaugh, correct?
Correct.
Okay, and you asked Mr. Merritt about these transfers?
I don't know if I asked specific dates and amounts, but I asked the defendant if he had access and the right to transfer money in the FB's PayPal account. And the answer was yes.
You asked Dan Cavanaugh, are you talking about Dan Cavanaugh now?
I was talking about the defendant. You already answered for Dan Cavanaugh.
No, I'm asking you for Dan Cavanaugh now. You said you talked to the partners, right? And now, a follow-up to that question is, did you do anything to check? I'll scratch that. Did you talk to Dan Cavanaugh about what he sent you to question the accuracy of it?
I'll restate what I've stated before. Both business partners said they had a legal right They were running the business, they were continuing to manufacture and distribute water features, and there would be money flow occurring. And the family members were trying to take over the business to make sure that the business didn't fail. So although I for sure was suspicious of the money flow, there was no way to prove without Joseph's words that the money flow was illegal.
Back to my question. These transfers that he sent you, did you check anything other than speaking to Mr. Cavanaugh and Mr. Merritt, whether what Mr. Cavanaugh sent you was accurate information?
I think I'm trying the best I can to answer your question. I don't know that I specifically said on this date, at this time, this amount of money, did you transfer that out? Because it wouldn't have mattered. What I asked is general questions. Do you have a legal right to transfer money within the business account? And the answer was yes.
If you could look through your report, you said that you talked to Mr. Merritt about these transfers. Can you find anywhere in your report where you asked Mr. Merritt about what Mr. Cavanaugh sent you?
Objection big, cumulative, and mistakes attempted.
All I have sitting in front of me, 106 pages of typed follow-up paragraphs of what I did on a daily basis. And I have an unbelievable amount of typed reports. So if you want me to review all of my reports to find something that specific, we're going to have to come back.
I don't want to do it now, but that's a good point, because we don't want to waste the jury's time. But I would like you to look at it at the break, okay? Would you do that for me?
You think I can cover my reports during the break?
Will you do the best you can?
Sure.
Okay, thank you. Based on what Mr. Cavanaugh sent you with PayPal, did you request any other PayPal records?
I've already stated no.
Okay. Did you request any banking information for Mr. Cavanaugh based on what he sent you?
I requested the Earth-inspired products and Joseph's financial documents.
Did you request any banking information at all during your investigation of Dan Cavanaugh's?
No.
Okay. Did you request any banking information of Mr. Merritt's?
I don't believe so.
Why?
I've already explained to you I was investigating the missing persons case, and all I had was Earth-inspired products and Joseph. I had no probable cause to reach out and start to look at any other citizen in America.
But if you could write letters and perhaps with financial institutions get information, maybe that would lead you to something. Maybe you find
Argumentative,
Sustained is argumentative and calls for speculation and conclusion.
I'm going to just shift gears. I'm trying to go chronologically, like you did in your report, because that's good and efficient. But I'm going to switch gears right now, and I'm going to go back in time a little bit to the search of the house. This would be on February 19th
Okay?
of 2010, correct?
Yes.
Okay. So let's start with how many people. You said you called it a team, right? Did I get that right? Homicide team?
Definitely a team.
Okay. How many in the homicide team were present and participated in the search warrant execution on February 19th?
Once again, I can guess. There's probably documentation that's more specific. I don't have that report in front of me related to the physical search of the house. But from memory, I had myself, a forensic evidence technician, a criminalist, a investigative specialist, persons from Department of Justice, cadaver dog persons. We had area detectives, homicide detectives. I'm going to say 10, about 10.
And of those 10 or so, we'll say, right, you had at least 3 forensic, specialists We call them forensic specialists or forensic techs. What would you call them?
Well, the forensic evidence technician is Dennis Williams, and she's basically handling evidence in my direction. And the criminalist has a totally different role. The criminalist is documenting the overall scene and assisting with any evidence that we would find. I don't remember if there was only one criminalist or if there was two. Many times there's two. And they are, I guess, they're crime laboratory personnel that are CSI for ease for the jury. They're CSI, just like you see on CSI.
And everybody is there with a common goal to find anything
You bet.
that would provide you with information as to what happened to the McStay family, correct?
Yes, and as we enter, anything is possible.
Right. And so all the precautions that you would use in a homicide investigation were used during the execution of the search warrant. Would you agree?
I agree.
Okay. And let's start with the cadaver dogs. Okay.
Before we get to that, why don't we go and take our morning recess, about 15 minutes. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case. Again, that means not discuss anything about the case, witnesses, testimony, exhibits, parties, or attorneys. And we'll see everyone back in about